5, 4, 3, 2, 1. Good morning and welcome to the Public Service Commission of South Carolina. It is Friday, October 14th, I think, 10 a.m. and we are here this morning for an allowable ex parte briefing. Let's take a roll call of commissioners to get started. Present in the hearing room, we have Commissioner Carolee Williams, Commissioner Caston, and Chair Belser, and with us virtually we have Commissioner Thomas, Commissioner Irvin, and Commissioner Powers. Couldn't find you on the screen, Commissioner Powers. Absent today is Commissioner Jay Williams. Let's see. This morning, as I stated, we're here for an allowable ex parte briefing from Duke Energy Carolinas, LLC, and Duke Energy Progress, LLC, in docket number 2022-62-56-E and ND-2022-62-E. Before we get started, let's take an appearance of the parties we have with us.
Madam Chair, Frank Ellerby, the Robinson Gray Law Firm, here appearing today for the Duke entities. I can introduce our presenters now, or perhaps you want to take appearances from the other parties first.
Let's take appearances and then we'll go through some ground rules and then get back to you for the start of the briefing, if that's okay. Who do we have as our designee of from the Executive Director of the Office of Regulatory Staff?
Thank you, Madam Chair, members of the Commission. My name is Ben Muschin. I am here as the Executive Director's designee in this proceeding. With me also today is Mr. Chad Torrey.
Welcome. As stated, today is an allowable ex parte briefing. The subject to be discussed and the subject that was noticed is Act Number 227 of 2022, Storm Damage Recovery. Also, I think we all refer to it as securitization. This matter has been noticed on the Commission's website as required by South Carolina Code Annotated Section 58-3-260C6. Today's proceeding will be conducted in accordance with the provisions of that code section. Part of the requirements are that an allowable ex parte briefing must be confined to the subject matter which has been noticed. I would therefore ask presenters, commissioners, anyone else to please refrain from discussing any matters not related to the specific topic. Further, the statute prohibits any presenter, commissioner, commission staff from requesting or giving any commitment, predetermination, or prediction regarding any action by any commissioner or the commission as a body as to an ultimate issue which either is or is likely to come before the commission. I also ask that any presenters, commissioners, staff, anyone that may have questions or making a presentation to refrain from referencing any article, report, statute, or document of any kind that are not included in today's presentation. This is because a copy of any document which is referenced during the briefing must be provided to the Office of Regulatory Staff for inclusion into the record in order for the Office of Regulatory Staff to certify this proceeding to the Chief Clerk of the Commission, Ms. Boyd. If anyone during the course of this briefing exceeds the scope or does not comply with or fails to conduct themselves within the provisions of Code Section 58-3-260, it is expected that a contemporaneous objection will be made. Finally, I need to remind everyone in attendance today, either in person or virtually, that you must sign in or register. Everyone in the hearing room or watching virtually must read, sign, and return the form which you were either given at the door or which will be emailed to you if you are with us virtually, which will include instructions and the deadline for its return. It is required by statute for each attendee, whether attending virtually or in person, to certify that the requirements contained in Section 58-3-260C have been complied with in this presentation. Mr. Muschin, as the recognized neutral for this proceeding. Do you have any additional comments or instructions?
Thank you, Madam Chair. Just a couple of additional comments. As you are aware, as the ORS representative, it's my duty to certify the record of this proceeding to the Chief Clerk of the PSC within 72 hours as to whether or not this briefing was conducted in compliance with the provisions of Section 58.3.260C. So I would echo your comments about the prohibitions of the statute, and the request is staying within the notice provisions. I would also point out that don't believe any of the information that has been provided in the presentation provided by Duke in this matter. I don't believe it's been marked as confidential, but I would ask the presenters to refrain from referencing or discussing any materials over which they would like to maintain confidentiality, and would ask that the commissioners please be understanding if Duke does decline to provide such information to the commission questions here today.
Thank you, Mr. Mustian. And to just follow up, I think, well, if anyone is new to this proceeding, there are some very strict timelines which must be met by everyone that has to certify that they were in attendance or provide their form. And then the Office of Regulatory Staff is under some very strict timelines to get materials back to the commission. So it is imperative that everyone complete their forms and submit them as requested very quickly, so that that these timelines can be met. If anyone fails to do so, then the proceeding cannot be certified, and we don't particularly want that to happen. So thank you very much, Mr. Mustian. Mr. Ellaby, we're going to turn the show over to you.
Thank you, Madam Chair and members of the Commission. Appreciate y'all letting us make a presentation today on the subject of securitization and the matters covered in the dockets that for which notice was provided. We have three presenters to you this morning. They'll start. The first one will be Tom Heath, who is the Corporate Finance Director, followed by Kamal Robinson, who's Deputy General Counsel, and Melissa Abernathy, who is the Director of Rates and Regulatory Planning. And I think they're going to be handing the clicker back and forth to each other as they proceed through the slides. And thank you very much. I will turn it over to them.
Thank you, Mr. Ellaby. Mr. Heath, Mr. Robinson, Ms. Abernathy, thank you for being here, and we look forward to your presentation.
Okay. Do we have slides up, or are the slides good to go? Or? Okay. Good morning, Madam Chair and Commissioners. It's an honor to be here today to talk about this important topic for Duke Energy's customers here in South Carolina.
Can you pull that microphone a little bit
Sure.
closer, please? Because
All right, is that better?
Yes, sir.
Okay, great. I'll start off covering kind of the benefits and considerations for the key stakeholders in a securitization transaction. And the first of those is the customer perspective. So in a securitization transaction, the goal is for customers to save, to achieve savings, or the goal is to achieve savings for customers compared to what customers would pay to the utility under the traditional method of cost recovery. And so the way that happens is we turn that stream of payments for customers from the traditional method of recovery to paying principal and interest and other debt service costs on highly rated, AAA rated debt instruments versus the weighted average cost of capital that would typically be paid on the unrecovered balance during the recovery period. All amounts that will ultimately be paid by customers for the resulting charges are going to go to a trustee, and they're going to be held at the trustee for payment of debt service on a semi-annual basis, and that cash is not available to the utility for its general corporate purposes. From the utilities perspective, instead of getting a stream of revenue over a period of time, over the recovery period, the utility gets a lump sum cash recovery of its underlying cost, in this case, storm restoration cost. And it can use that cash to fund other investments, or most likely in the case here, it would be to repay debt and equity that were raised to fund those storm costs over the last several years. And from the regulatory perspective, your perspective, you do not give up any right to determine the prudency of the underlying storm cost. And the bonds here, in this case, would only be issued after the commission does a level of due diligence and review of the, not only the storm costs, but the process leading up to the issuance of the bonds, and determines that that transaction, contemplated transaction, will in fact deliver customer savings compared to the traditional method of recovery. Oh, no, back one. Yeah, there we go. So securitization is a proven financing structure that's been used to recover storm restoration costs in various states since 2007. There's been 23 transactions that were conducted since 2007, raising $14.5 billion to fund that storm restoration activities. $1 billion of that was done by Duke Energy in North Carolina last year in November of 2021. To accomplish a securitization transaction, there needs to be enabling legislation, which we now have in the form of Act 227. And we'll talk about the details of that statute in a few minutes. It also requires a financing order from the Utility Commission. And that financing order would describe would state the amount of costs that are eligible to be securitized. It would determine the transaction structure and the degree of flexibility provided to the utility in terms of executing a transaction on behalf of customers. That could include ranges of interest rates that you would expect to achieve, the tenor of the recovery period, and other factors that you consider relevant to that transaction. Also, very importantly, it would establish a true-up mechanism, which allows for the utility to assess charges on its customers at a level to recover and pay semi-annual debt service on the bonds that get issued. Those bonds themselves would be AAA rated securities, which is the highest credit rating available in the debt capital markets, and should result in the lowest interest rate or coupon on that debt compared to other debt in the capital markets. The bonds would be backed by the right to impose, bill, and collect charges from Duke Energy Progress, in this case as customers, on a non-bypassable basis. And that charge will be assessed on all existing and future customers with limited or no exceptions. The bonds will be issued not by the utility itself, but by a newly created special purpose entity that's created just for the purpose of issuing this debt and collecting charges from the utility's customers to service that debt. And as I mentioned earlier, all cash that's collected on behalf of the SPE will be transferred to a trustee, and that trustee can only use that cash that it has to pay debt service on the bonds and for no other purposes. There are three key stages to a securitization transaction. The first is legislation, and that now is in place here in South Carolina with Act 227, as I mentioned earlier. And that legislation allows for the issuance of securitization bonds, or ratepayer-backed bonds, you may hear that term as well, to finance certain cost in an alternative to the traditional method of cost recovery. And that legislation mandates an irrevocable financing order from the Utility Commission, and it authorizes the creation of an intangible property right, which is the right to bill and assess charges from customers, again, on a non-bypassable basis. And it implements a true-up mechanism in addition to some other requirements of the rating agencies to get a AAA rating on the debt. The next phase is the regulatory phase, which we are in now here in South Carolina for DEP. And the first part of that is the cost recovery review. So there is a proceeding ongoing now where the prudency of the underlying storm restoration expenses are being determined. Once that proceeding concludes and there's an order on prudency of the underlying cost, the expectation is that the utility, DEP in question here, would file a petition for a financing order. And that financing order would include testimony from utility representatives as well as potentially from commission staff and interveners, including the ORS. In that proceeding, the company must demonstrate that it expects to achieve customer savings compared to the traditional regulatory model. That financing order would then also authorize the utility on behalf of the SPE, which is going to issue the debt, to charge customers and collect those charges and to adjust the rates to ensure enough cash is collected to pay debt service on the debt. Once the financing order is received, then we move into what's known as the post-financing order phase. And there's a potential for a bond advisory team construct to participate, for the commission and ORS and others to participate in that process that leads up to the ultimate issuance of the bonds. During that phase, we would prepare transaction documents, which would be a number of agreements between the utility and the SPE issuer, including a purchase and sale agreement of that property right that got created in the legislation and in the financing order, as well as a servicing and administration agreement between the utility and the SPE. So this SPE issuer won't have any employees, it won't have any kind of corporate infrastructure, so it's going to rely on the utility to conduct services on its behalf, to administer those charges, make those collections, send that to the trustee, make those debt service payments, and so forth. So there's documents that govern that activity between the utility and the SPE. And then there's all of the bondholder or potential investor-facing documents there as well. So indentures and other documents that are necessary to have that debt issued. There's also a registration process with the Securities and Exchange Commission. So this entity that issues the debt will be a new entity. And so the SEC has to review this entity, and it can ask questions around the structure of the entity itself, as well as the structure of the debt to be issued. And so that process takes several weeks, probably 6 to 8 weeks to conduct that SEC process. And then we have to work with rating agencies. So again, this is a new entity. We have to present the structure and the legislation and the financing order to the rating agencies and work through a diligence process there for them to come to the conclusion that AAA is the right rating to put onto the debt. So that again takes several weeks. Once those SEC processes and the rating agency process are checked, we would then move into the kind of the marketing phase of the transaction, where we would have discussions with potential investors, going over the structure with them, going over the unique aspects of the DEP South Carolina territory compared to other transactions that they may have looked at in the market, to kind of discuss the relative strengths of this transaction. And then we would move into the pricing phase of the transaction, and then the post-pricing aspects, which are providing an issuance advice letter to the commission, provides you your final kind of sign off on the transaction before it were to proceed. And then we would implement customer charges and then adjust those charges as necessary going forward throughout time. So the next couple of slides are showing how those customer savings ultimately get derived. So in a traditional regulatory model, as you're aware, the customers pay the weighted average cost of capital generally on the unrecovered asset or on the rate base of the utility. And that weighted average cost of capital includes the allowed ROE that the utility has approved by the commission, and the embedded debt cost of the utility, as well as depreciation or amortization of the underlying asset, and then any operating expenses. So we take that recovery mechanism and turn it into this securitization recovery, which is interest expense on AAA-rated debt, principal amortization of the debt, and some small amount of ongoing transaction expenses. From the utilities perspective, again, it's exchanging that monthly cash flow stream over the recovery period for a lump sum cash recovery of its cost up front. So this slide is just showing some assumptions that we would have in terms of a traditional recovery of a $200 million asset versus securitization recovery of that same $200 million asset. And I won't really go through all those details on that screen, but the green check marks are indicating that that's an assumption that's applicable for that structure, traditional or securitization, and the red X's are saying that assumption is not applicable for that particular method of recovery. Okay. So using those assumptions on the prior slide, we would get into a revenue requirement under traditional recovery for that $200 million asset of about $36 million a year. That would include $20 million of amortization of the underlying asset. This is assuming a 10-year straight line recovery. And then $16 million of return on the unamortized asset. Compare that to a $27 million revenue requirement under a securitization model, which consists of $16 million of principal amortization, $10 million of interest on that underlying debt, and then $1 million of ongoing expenses. So you can see there that the true driver of the customer savings is displacing that return that the utility would earn under the regulatory model, the traditional regulatory model, with interest on the AAA-rated debt. So I'll have Mr. Robinson then talk about specifics of Act 227.
Thank you very much. Good morning, Madam Chair, fellow commissioners. Thank you again for having us here today. As Tom indicated, I'm going to be here to speak about the specifics of Act 227. Tom walked through a nice general overview of securitization, why it works, how it works, who benefits how, and I'll walk through the very details of what Act 227 in particular actually enacted. Before I do that, though, I want to say, give you a couple things about me. So one, I'm a process guy. I love process. And so what I find fascinating about securitization is it's uniquely where there are three kind of pillars of process that need to accomplish. You have the legislative process, you have the regulatory process, then you have kind of like the free market process, right? That third portion. And each of those processes are equally important. They all have their own specific rules, procedures, considerations, requirements. And so because of that, it ends up being a complex framework because you have to account for all of the different portions of that process. So I find it interesting given the legislative, the regulatory, and as well as the free market interplay on securitization. The other thing that I will say about me is it's probably more of a disclaimer, but I am not a bond expert. I know probably enough to be slightly dangerous, but maybe not even that much. I'm also not a corporate finance expert either, and that's why I wanted to make sure that my colleague Tom Heath spoke before I did. I'm a regulatory attorney through and through, and so I have to, in my mind, to always recognize and conceptualize securitization from a very simple framework. You have the first aspect of, can you do it? And that's a legislative piece, right? Can you actually have some enacting legislation that allows you to do it? Then you also have that, assuming that the legislation gives that commission the authorization to proceed with this, then you have the financing order phase. That's still part of the can you do it. You have the element of the should you do it? And if you should do it, how do you do it? And so that should is part of the company's burden of proof and laying out what the framework is, the quantifiable benefits, which again, things we'll dive in a little bit deeper on in a few minutes, as well as the overall framework of the financing order. What is the framework that you need to employ to be able to actually go out and do it? And then that third phase is go do it and do it as cheap as you possibly can. And so that is really the the dynamics of the financing order, the structuring, the marketing, the pricing phase, coming back to y'all at the end of the day and saying, here's what we've done, as well as, and what's also interesting about the framework all through all phases of the can, should, and go do, is a lot of the provisions that Tom talked about and we'll continue to walk through here are all about, and I told you about that market force piece, all about making investors comfortable. What are all the parameters, provisions, the things that we can include? And that goes to the structure, the bankruptcy remote piece, that's the non-bypassability of it, the irrevocability of it, things of that nature, to ensure that at the end of the day, that investors feel confident, that credit rating agencies feel confident to give this the highest rated bond, and ultimately investors say, okay, I'm willing to put my money on it. I'm pretty secure that I'm going to get my money back over that course of period of time. And so from a risk perspective, it's not that high, and so I'm able to price it low. And so that's really what it's all about. All of the complex framework is to get to that aspect of giving the authorizations and also ensuring that you have all of the certainties and low risk in place for investors to feel comfortable to bid and bid low. So I will now walk through more specifically Act 227, but I thought that might be helpful for y'all because it certainly has been helpful for me navigating through understanding this very complex framework. So I'm going to move, thank you, Act 227. So Act 227 does a number of things. It's as you know, very detailed and long, but I did pull out a few, I think, of the most pertinent aspects of the Act that I wanted to talk to y'all here about today. And so the first portion of the Act that I wanted to flag is, of course, the legislation authorizes the Commission to create that intangible property right. What does that mean? Tom talked about the regulatory asset being able to actually develop and use the costs that have been incurred, that have not been recovered yet, and being able to convert that into a financial instrument that can now go into the market for investors to bid on and ultimately become bondholders. And so not only do you have that right that's being created through the legislation, but you also, through the legislation, make it very clear that customers can't ever bypass the ability to reimburse, ultimately, the bondholder for the charges, both present and future, from a distribution and transmission customer perspective. So again, if you think about it from the market force, how does the market ensure that they will be repaid under all circumstances if they were to bid? And that non-bypassability aspect, the irrevocability aspect, are all important to do that. And so I hit the first two there, and those are the references to the statutes that I just flagged. The other aspect too, again, you think about it from the market force perspective, is, and I'm going to put this in huge quotes because it's not really a state pledge, but it is a pledge from the state that it will not interfere with either the Commission's financing order, in addition to also kind of pledging on behalf of the Commission that y'all won't interfere with the financing order once issued. And that, again, is that security to the investor that if I bid on these, there's not going to be any form of framework or change for these particular bonds that would interfere my ability to be able to be repaid. Why I put the state pledge in quotes, I think y'all are aware, it's not backed by the full faith and credit of South Carolina, so it's not a government bond, at least from our perspective, but it is very clear that there are some articulated pledges to the bondholders ultimately that we're not going to do anything to interfere with your ability to recover these costs at a later date. The other thing that I will flag here, and we'll talk a little bit more also, but Act 227 in particular includes a requirement for a post-financing order pre-bond issuance process. Every state does it a little bit differently, but this is ultimately once you have issued your financing order and you've now told the utility, go do it, there is a process that needs to be implemented to ensure that there is, to make sure the Commission and others are comfortable with the framework that's going to be employed, and to give the Commission the information that it needs, ultimately when we come back with the transaction, for you all to say, okay, we're comfortable with the information that was provided, we're comfortable with the process, go ahead and move forward. And again, I'm going to talk about that a little bit more in a couple minutes. And then finally, as my colleague mentioned, the requirement for the formula-based true-up. So ultimately, again, think about it from a market perspective. A lot of the storm recovery charge, the calculation, the computation is going to be based off forecasts. What's the load? What's the weather? What are your customer profile, et cetera. And so making sure that there is a mechanism for at least an annual true-up to ensure that the charge is in truly collecting the amount it needs to collect over whatever the maturity period of the bond happens to be, so that that investor feels comfortable that, okay, let's say you have the charge based off of this, and then something crazy happens, right? Either the weather's too mild, or the weather's too aggressive, or some other, or you've missed your load forecast for whatever particular reason. That there can be some modifications to the charge to ultimately ensure at the end of the day, if it's a 20-year maturity period, that bondholder's being paid back over that 20-year period. So that's another key element of Act 227. I'm gonna move on to, all right, continued. So again, process guy, I envision the regulatory process at least to be in 3 phases. That phase 1 aspect is, as my colleague mentioned, is what is going on right now. And that is the ultimate audit of the storm recovery costs that the company has incurred. ORS is actively auditing those costs as we speak as part of that docket. I know that y'all are aware of, and it's been noticed here. Phase 2 is around the financing order process. So the actual, what I call kind of the terms and conditions that the commission will ultimately have to issue to determine and lay out the structure in which the company is able to structure market price the bonds, in addition to things such as the calculation of any financing charges, financing costs, as well as the overall structure of the issuance of the process of the transaction, as well as the storm recovery charge computation. Things of that nature are all included in that financing order phase, as well as the pre-bond issuance process as well. Other things as part of that terms and conditions of the financing order include that state pledge that has to be articulated in there, as well as the terms, examples of transaction documents that my colleague Mr. Heath mentioned. All of that is included in the financing order. And then phase 3 is the actual go do it, the structuring, the marketing, the pricing, the actual engaging with the market, engaging with investors, credit rating agencies, getting pricing for the bonds, and ultimately at the end of the day, coming back to the commission with what is known as an issuance advice letter for consideration. And so in my mind, phase 1, 2, and 3, phase 1 is at least 6 months. I should mention with the phase 1 aspect, just for y'all to be aware, obviously we're doing a separate a separate proceeding for phase 1. However, there's really 2 options in which these costs can be audited, either through this separate transaction, through this separate proceeding that we're ongoing now, or it can be done in a rate case. The traditional way, so to speak, of actually evaluating the prudency, the reasonableness of the costs, and then being able to proceed with, I think, some time limitations with the financing order process. But in this circumstance, given timing, we proceeded with the storm securitization audit as a separate proceeding. That will take about at least 6 months. And then phase 2 will be about 4.5 months from start to finish. And then, of course, phase 3 taking hopefully no more than 6 months, given needs for flexibility and efficiencies and things of that nature. Why are things so fast? Because you're dealing with the market. And so the market's changing. I think we're witnessing that on a daily basis. I know that, what was it, yesterday, where I think the market tanked and then all of a sudden just raised up within an 8-hour period. I mean, it's really that fluid. And so making sure that when we come in with y'all with our forecasted calculations, our forecasted carrying costs, our forecasted storm costs, our expectations of what the market is going to bear, that we actually have it within a framework and time in which that the market conditions are probably less likely to be modified or significantly different. Certainly can never make that guarantee, but that is really the intent behind the tight timelines. Got to make sure that the estimates and the forecast are as close in time to the actual go doing it as possible. All right, I'm going to move on to my final slide. All right, and I thought that this might be helpful. So I know the statute's very long, and I know there's different pieces. So I pulled out what I thought to be some of the key points that are specific to the commission. Like what does the commission have to do throughout this process, throughout the 3 phases, frankly, not even just phase 1. And so I hit a few of them from our view. So 1, the decision around the storm recovery costs themselves, what amount are reasonable and prudent based off of the storms that my colleague, Ms. Abernathy, is going to speak to next, and will be ongoing through phase 1. That'll include, of course, the storm recovery costs, carrying costs as well, a real deep dive into that, which I indicated is ongoing as we speak. The second portion that I thought was a key point was that issuance of the financing order, which again, what I call as the terms and conditions. What I think is going to be unique about this transaction proceeding for phase 2 than perhaps the commission may be used to is we are actually going to, at the time of our petition, we're actually going to file our proposed financing order at the time. So I know typically the proposed order comes at the end after everything is resolved or at least litigated and heard. In this instance, the financing order comes along with the petition. So you'll see the company's proposed layout of the terms and conditions that include all those parameters at the time that we file the petition. Oftentimes what may happen if the commission loves and the parties love our financing order, then that's what we'll propose. If there needs to be any modifications or recommendations or the proceeding has highlighted things, then what will likely happen is there may be a revised financing order towards the latter part of the proceeding, say after a hearing if one is required, that gives any additional modifications based off of any discussions throughout the docket. But you'll get a financing order, it's relatively lengthy, probably 70 pages or roughly, as part of the petition. And so we will hopefully do a lot of the upfront work for y'all as part of that. The other thing so within that financing order, there will be certain findings that are going to be critical. One, the quantifiable net benefits test that Tom spoke about previously. That's the should you do it, right? Are you actually going to save customers money? And if so, what's your projection of how much? And depending upon what that projection is, and if we are showing that we're going to be able to save customers money, then that goes into the decision as to whether you should move forward with the securitization or not. The establishing the storm recovery property right as the legislation authorizes for y'all. That, of course, will be part of the financing order itself of establishing that. Investors need to see that, will want to see that. A finding that the structuring, marketing, and pricing of bonds will result in the lowest storm recovery charges consistent with market conditions at the time of pricing. Mouthful, but ultimately what that is indicating is we will be, and we in fact will be certifying that we got the lowest charge. So we will be going after zealously the lowest storm costs with regards to the different bondholders that may be at play. How do we ensure that we keep those prices low as possible? And how do we do that comparison within the market to show that the commission ultimately that we got the lowest prices as possible? It does put in the consistent with market conditions, because if we come with y'all in day 1 and day 5, some market miracle occurs and all of a sudden now things have shifted. We want to make sure, and I think the legislation accounts for the fact that market conditions are market conditions, and so we can't predict. We can do what we can within the overall framework of the market, but obviously recognizing that there are market forces at play that we have no control over. The other aspects of the finding is the non-bypassability, which I mentioned before, and the fact that it must be paid in full by customers over the course of the maturity period. Y'all have heard that, as well as the formula-based true-up mechanism, as I mentioned before. The establishing of the post-financing order pre-bond issuance process is also another key point that is specific to the commission. What I wanted to mention on this is the company does plan on proposing in its part of its petition what that pre-bond issuance process should look like from our perspective. We're still noodling it over as we speak. The point is, and our viewpoint is, that it has to have the right balance between the need for flexibility and efficiency. I think y'all are already counting the numbers of time equals money, especially in the market condition. So how do we develop a process that is efficient, that allows for flexibility to be able to respond to market forces, as well as ensuring that the commission has the information that it needs, consistent with, of course, its evaluation of the issuance advice letter, as well as to comport with the statutory requirements and regulations. Different states do it a bit differently. You have certain states that will do a formal, what is known as a bond advisory team. North Carolina has that, or Florida has that. I believe also California has a formal process as well. Different variations, even within that formal BAT team, is who participates. North Carolina, for example, their decision was they wanted the commissioners. It was actually 3, I believe, commission representatives, public staff representatives, company representatives, underwriters, and I'm sure I'm missing 1 or 2 other groups, met once to twice a week for 2-3 hours every week, and going through that process. There's pros and cons to that type of an approach. Florida, slightly different. I think it was a commission representative that attended that. However, there was a provision in which if there was some form of a disagreement, then we'd have to go back to the full commission for that. pros and cons to that approach. Others have a framework in which you have the meetings where the company, it's with the underwriter, and then other representatives are able to call in and listen in, but it's not a mandatory attendance. Those exist as well. One aspect of Act 227 that I did not mention, but is important, is that there is a requirement as part of the issuance advice letter process that an independent third party must certify to ultimately the lowest storm recovery charges consistent with market conditions, et cetera, et cetera. Our view of that, of course, is that independent third party would be someone that is not consulting with any participant as part of the transaction or as part of the framework. Now, with that said, the independent third party, given the fact that they need to make those certifications, should be involved from start to finish, and all of those calls should be a mandatory attendee, because at the end of the day, we want to make sure that party has the information it needs to be able to make that certification at the end of the day. Other aspect that I will mention also is the review the issuance advice letter and that process that undergoes after we have priced the bonds. Prior to issuing the bonds, we come back to the commission. I feel like the issuance advice letter reference is probably a bit of a misnomer, because it's not just a letter in the traditional sense. It's very detailed, has a number of different aspects to it. It includes, of course, our pricing in what we call tranches, in case you have to break up some of the dollars, the amounts, and have to be, maybe a particular bondholder only wants 50 million of the 223 million approximately of money. We have that's a separate tranche, may have a separate pricing, so on and so forth. And so all of that framework, the breakdown, the structure will be included, as well as our calculation of any ongoing or upfront financing costs. Things of that nature will be included in there as well. In addition to the storm recovery charge computation, final, if there were any estimates at all, everything being trued up before the commission ultimately makes the decision at the end of the day to be whether or not to proceed with the transaction or not. You see the reference of either accept the IAL or issue a stop order. Our intent and goal is to ensure that y'all don't feel compelled to issue a stop order. That's our biggest goal. Obviously, if you do, it would have to kind of restart the process, and also does cause some concerns, I think, in the bondholder world of, well, if the stop order has been issued, do I now have to price in the risk that a stop order will be issued again? In addition to that, also, I recognize, and I know the commission, I'm sure, is not too thrilled about this, but it is a pretty short turnaround time for the issuance advice letter. I believe it's 4 days max. That, again, is because of the market conditions aspect. You imagine from an investor perspective, if they're bidding based off of current market and they have to say, let's wait a month before there's a decision as to whether or not to proceed or not, either they're not going to want to participate, or they may price that risk in to the bid, which ultimately may potentially drive up that price. So it is a pretty short turnaround time for market condition reasons. And then finally, with regards to the IAL and any decisions, it's the company's recommendation that we have to ensure that the IAL process does not result in an appealable event. So an issuance of an order may result or cause an appealable event. As you know, that runs an additional time period for folks to have the opportunity to appeal. Again, you're building in time that, an investor may end up conclude, either I have to price in the risk that 20 days from now, this may not be a good price for me, or otherwise. And so building in that aspect is also very important. And then, of course, the review of the periodic true-up filing as well process. So that, as I mentioned before, is that at least annually, likely we'll propose at least semi-annual true-up filings as part of that process. One other thing I neglected to mention with regards to the post-financing order pre-bond issuance process, as I said, we're still noodling over what that will look like. I do think there's one important aspect that we do know definitively. I think the company's recommendation is going to be that we still have primary, if not sole, decision-making authority ultimately at the end of the day for the structuring, marketing, and pricing as part of that process. There's several reasons for that. One, it's the cost that the company has incurred, so it has to be the one to be able to make the decision as to whether it feels comfortable moving forward with the securitization. It's also the company's burden of proof before the commission that we got the lowest storm recovery charges. So if the market is not what we think it should be or can be, having the opportunity, the ability to be able to either pause or move forward, I think will be important. And then another aspect that I think is also very important is there are a number of SEC rules and regulations and requirements especially for marketing to investors. It's called, I believe it's Section 11, SEC rules and regs. We have a strict liability under that, and basically what that is we have to make sure that every investor gets the same type of information and nothing more and nothing less than another. And if it's alleged and it's found that in fact occurred, we have a strict liability. There's no defense at all. We have to ultimately have some type of a redress. And my understanding is the ultimate redress under that framework is an investor can say, buy my bonds back. And obviously, if the bonds are making money, if it's a good decision, most won't. But if for whatever reason the bond is not making money, if let's say the market is over under, I'm sure an investor would look for any opportunity to try to maybe renege on the deal. So we have these requirements. It's only us that has those requirements. And so we want to make sure that we do have ultimate decision making on whether to move forward and presenting the bonds for issuance to the commission. With that, I will move it over to my colleague, Mr. Abernathy.
Thank you. Good morning, commissioners. Can you all hear me? Okay. So I am going to cover the specifics of the storm restoration costs that we've included in the storm securitization docket and do a quick little history of the storms that we experienced, the costs, and then the history around our deferral request and approvals. So our storm securitization request includes costs related to 8 storms. Each of those storms were extraordinary in nature, and for each of those storms, the company incurred incremental costs to quickly and safely restore service and power to our customers. So the first storms that are included, I don't know. There we go. The first storms that are included occurred back in 2014. Winter storms Pax and Ulysses. Those storms occurred in early 14, and the company requested a deferral of those costs, and the commission granted that deferral in January of 2015. In 2016, the company filed its first rate case in over 25 years. And in that case, those deferred balances were included in rate base. However, the company proposed and the ORS agreed in settlement to delay the amortization of those costs to a future date and instead continue the accounting order that was in place as a way to mitigate customer impacts of that rate case. So when we fast forward to the 2018 rate case, those deferred balances were still on the books. But at that time, the company proposed to remove those balances out of rate base to accrue a return on the deferred balance in order to pursue securitization as an alternate recovery mechanism to save customers money. So then we fast forward to 2016. Most everybody probably remembers Hurricane Matthew. It was a huge storm that impacted our service territory. It actually occurred, I believe, during the 2016 rate case or right around that timing. And the company requested a deferral of the incremental costs related to Matthew. And in January, the commission granted that deferral. And then in the 2018 rate case, similar to the earlier storms I was discussing, the company proposed to remove those amounts from rate base to pursue securitization as an alternate recovery mechanism to save customers money. The next 2 storms that are included are Hurricanes Florence and Michael. Hurricanes Florence and Michael were kind of a 1-2 punch in September and October of 2018. Similar to the prior storms, the company requested a deferral of the incremental costs related to those storms, and the commission granted that deferral. I believe those storms happened right before we were filing that 2018 rate case. And in that 2018 rate case, we opted to remove those deferred storm costs from rate base to pursue securitization as an alternate recovery mechanism to save customers money. Then we have Hurricane Dorian that occurred in September 2019. Similar to the prior storms, the company requested a deferral of those costs, and the commission approved just adding those Dorian costs to the prior storm deferral. And then last but not least, earlier this year, we had winter storms Izzy and Jasper. Those occurred in January, and our deferral request for those storm costs is included with the storm securitization docket filing. forgot to move the slide. This slide shows our projected total balance of deferred storm cost. We've got it separated by storm. And one thing to note is this is our projected balance through February 2024, which is our anticipated securitization date. This shows the deferred O&M cost as well as deferred capital cost and the carrying charges the company has incurred on those costs. In total, in the securitization docket, we've filed for $223 million of storm restoration cost, and these are the costs. These costs and these calculations are what are currently being audited by the ORS, and the final numbers will be finalized as we proceed through phase 1 of the storm securitization docket. So that's the summary of the costs that we're including in this securitization proceeding, and I believe Tom now will talk a little bit about our North Carolina transaction.
So in November of last year, we executed 2 financings, one for DEP, one for DEC. The purpose of those was to recover the North Carolina portion of cost related to hurricanes Florence, Michael, Dorian, and Winter Storm Diego. Those were 2018, 2019 events. Those financings resulted in significant savings to our North Carolina customers, about 37.5% for DEP and 34.7% for DEC over a 20-year period. And of course, those savings are compared to recovering those under the traditional method of having those in rate base. And just for reference, for a residential customer in DEP, the charges that we initially set were about $2.44 a month, and for DEC, that was about 49 cents per month. These transactions struck an appropriate balance between delivering customer savings and timely and efficiently recovering costs to restore our system after those hurricanes and winter storms. This slide has a table of kind of summarizing these 2 transactions. So for DEP, we issued $769.6 million of bonds, $237.2 million for DEC's North Carolina customers. Those both recovery periods are over 20 years, and you can see the weighted average interest rate achieved on those transactions in November of last year, 2.45% for DEP, 2.43% for DEC customers. Revenue requirements there of about $50 million a year for DEP and $15 million for DEC customers. And then over the life of that 20-year recovery period, savings on a net present value basis to DEP customers of $235 million, or the 37.5% I mentioned earlier, and $63.9 million, or 34.7%, to DEC's customers, again, over that 20-year period. So $300 million roughly in total savings over a 20-year period of time for our customers in North Carolina. This next slide, though, shows Treasury rates in October 2020, November 2021, around the time that we priced the bonds, and then at rates as of last week across the different Treasury maturity spectrum, so 2 years to 20 years. And so you can see a significant increase in underlying Treasury rates between those points in time. So the point of that being that rate movements and the market environment and the interest rate environment at the time a transaction is done is ultimately what's going to determine the level of customer savings compared to the traditional regulatory method. And so in a rate environment that we have today, I would say that 35% roughly of savings that we achieved in North Carolina is probably not a benchmark of what we would ultimately deliver on a transaction for South Carolina customers today based on those interest rates. The next slide is just kind of a timeline of that North Carolina transactions, or those North Carolina transactions. So those storm events were in September 2018 and September 2019. The enabling legislation in North Carolina, Senate Bill 559, was passed in November of 19. We filed a petition for a financing order in October 2020. We had a hearing on that proceeding in January. We got an order ultimately in early May of 2021. And so that kind of wrapped up the regulatory process, and then the rest of the timeline here is that post-financing order process that Kamal talked about. So rating agency work, SEC registrations work, investor discussions, and then actually having that transaction in the market for a number of days, collecting orders and determining pricing levels, leading to closing that transaction in November of 2021 and putting charges on customer bills beginning in December of 2021. And then this last slide is kind of showing the structure that gets put in place to affect a transaction of this sort. And so there's a lot of arrows and boxes here, and I'll kind of walk through these one by one. So the color codes, the numbers and the arrows are kind of color coded to the text on the left side. So first, or the second outcome really, although it's not labeled, but it's number one here, is receipt of the financing order. So the financing order issued by the State Utility Commission instructing the utility to go forth and issue bonds. So we would go forth, we would go through that entire post-financing order process. We would price bonds, and then the rest of these flows are really happening from that point forward. So the utility is going to sell that property right that the financing order creates to this SPE issuer for cash. That's number two. That cash is going to come from proceeds from issuing the debt from the SPE to the note holders. So that cash will come from note holders to the SPE to the utility, and at that point the utility's regulatory asset is recovered in full, and everything going forward from that point is charges being assessed on behalf of the SPE to customers. Those charges are set by the company or by the utility as the servicer of the debt, or the servicer of the bonds underneath the servicing agreement between the SPE and the regulated utility. All the cash collected on a daily basis is sent to the trustee, and the trustee holds that cash and invests it in very low risk, high quality, overnight, short-term investments to earn a small return to also be used to pay debt service to bondholders on a semi-annual basis.
That concludes at least our presentation. Happy to take any questions.
Thank you. Commissioners, any questions?
Madam Chair,
Commissioner Urban?
thank you. Thank you for your informative presentation this morning. My first question is that since irrevocable charges will appear on ratepayers' monthly bills and cannot be removed by future commission action, who has the responsibility for informing ratepayers that they will see for the first time a new charge on their bill, and how and when is that communicated to the ratepayers?
Sure, thank you. I'm happy to answer it, and I'll definitely will take any additional supplements from my colleagues, but ultimately through a number of processes. So obviously right now we have the notice to customers resulting from the phase one framework articulating that there is a process that is under play that is auditing the storm costs, and ultimately at the end of the day would result in, assuming securitization is approved, a separate line item on customers' bills. I believe there will be a subsequent notice at the time of the phase two process with the financing order issued, in which that notice would also be articulated about that phase. And then my understanding is at the time that the issuance advice letter is issued and the commission's time frame, I believe there is also a notice provision prior to the actual charge showing up on customers' bills, showing the actual storm recovery charges that will be charged to those customers. So there'll be a number of notifications throughout the process to customers of where things are.
Thank you for that explanation. As you can imagine, since this is the first time that securitization is being considered in South Carolina, I'm sure the ratepayers are going to have questions. And have other state commissions held public hearings on a pending securitization issue? Did North Carolina, for example, do that?
Commissioner Irvin, we would have to look back to see if other states do the public hearing. I am struck. I don't believe there was a public hearing for North Carolina as prior to the process. Now, a reason for that being, potential reason for that being, excuse me, was that unlike in this particular transaction, 222-256-E, that's being undergoing South Carolina currently right now, the review and audit of the storm costs in North Carolina occurred during the rate cases in 2019 of both of those companies, the DEC and DEP for North Carolina. And so the notification of the rate case and resulting charges from said rate case included at the time of filing the storm recovery cost as part of what ultimately would be the charge to customers from the increase in revenue requirement that the case requested. So long story short, I probably rattled on too much, but I don't believe there was a public hearing because it was incorporated as part of the rate case process, which is where the review of the storm costs originated in North Carolina.
And I assume that the Office of Regulatory Staff will have a significant role, and they do the initial audit of the storm costs that are being asked to be securitized.
Yes, sir, that's correct. Obviously, will not speak for the ORS, but I can tell you that I have folks back in my shop right now responding to discovery resulting from the review of the storm costs. So I can, at least from my perspective, unequivocally say yes, they are doing a very thorough job.
And I'm glad to hear that process has begun. I assume that the ORS will file a report and recommendation based on their audit review. Is that how you understand it?
So I will, will not speak for the ORS, but from a procedural schedule framework, their testimony on the phase one, I believe, is December 15th, if my memory serves me correctly. So yes, that's correct from my perspective.
Since ratepayers assume all the risk associated with payment of the ROC bonds, isn't it true really that the utility risk disappears when the utility receives a financed upfront lump sum cash payment of the sale or closure?
Sir, respectfully on that, Commissioner Irvin, I think that the company disagrees. I mean, first and foremost, I think our focus, and we continue and are proud of it, we do our best to keep costs low across the board. So the natural incentive to get and derive the lowest storm recovery charge would exist with or without any requirements to do so. Several reasons for that. One, we want to make sure that our customers are handled and taken care of. Two, the other element of that being there's a recognition that as the company is continuing to make its investments and continue to recover costs across its business, that there is a recognition that there's the moderation to rates. So we want to make sure that rates across the board remain low, so the company is able to continue to recover its costs prudently without undue interference to customers. In addition to that, there is a specific certification that is required under the statute, as well as the company is making the commitment that we will certify that we derived the lowest storm recovery charge consistent with market conditions, et cetera. And so there are both general overview incentive to do this, do this as well as possible, but also a specific requirement that requires us to ensure and essentially certify that we got the best charge. So there are a number of incentives and a number of reasons why we would obtain the lowest charge. And the other thing that I will identify for that, sir, is within the corporate financing space, and I'll brag for Mr. Heath for a quick second. We've done a number of transactions in the corporate financing bond framework. That's something that is done on a daily basis. I think our experts at Duke are unparalleled to none other. And so I do believe that we have the right folks that know this stuff very well. And I think that's evident by even our general blended debt rate across the board. Obviously, I will not touch on other dockets, but I think the commission's aware of there's something in the works currently right now where the commission has that information in front of it and can judge themselves as to whether our debt rate for DEP in particular is appropriate and consistent with overall market.
And I appreciate that explanation, and I understand that, if done properly, both the ratepayers and the utility stand to benefit. It's a win-win. Isn't that true?
Absolutely, sir.
Okay. And I guess my point is that we have a very important role up front in assuring that the process is in the public interest and serves not only the utilities' needs to lower cost, but the ratepayers' need to benefit correspondingly by reducing their long-term cost. Would you agree with that statement?
I absolutely would, sir.
Thank you. And so, isn't it true that most public commissions have engaged their own independent expert to review this process? And as you mentioned, some have used panels, others have used experts on securitization to look at the regulatory and legal aspects of the transaction. That's a fairly common practice, is it not?
So I can't speak for every jurisdiction, but yes, it is a common practice that the commission, as we would expect, would have some either consultant or at least rely on or delegate that need for a consultant to another, perhaps maybe the ORS or some other form of framework in which either the consumer advocate or someone to that extent would have the ability to be able to hire a consultant and provide a particular viewpoint. But absolutely, it is common, at least from my perspective, and at least the transactions that I've been involved in, or at least have watched or observed or read about, in which there was a consultant that the commission retained. Which I also understand. I'm sorry, sir. Go ahead.
No, go ahead.
I was going to say, I also understand that the statute, Act 227, also allows for the ability for this commission to be able to hire a consultant in addition to the ORS.
That was my next question, so thank you for pointing that out. And if we do our due diligence, that actually serves the process best by further informing potential buyers of the bonds that this is a credible transaction and in the best interest of the purchasers of bonds. Wouldn't you agree with that?
So my view of it, Commissioner, is I think the commission should have the consultants and the expertise that it believes it needs to evaluate the transaction from start to finish. The viewpoint from the company is in addition to that, and recognizing that the regulatory process will also ideally get to the right result for how to structure, market, and price the bonds, that I think the process itself ends up deriving that trust, in addition to a very clear, articulated financing order. But certainly, if the commission feels it needs a consultant to be able to assist itself in reviewing all aspects of it, then by all means. And certainly from the statutory perspective, the requirement for an independent third party, whoever that may be, also being involved, I think also gives that additional public transparency to an independent actually certifying that we did in fact achieve what we said we were going to do.
Thank you very much. I appreciate that. And finally, you mentioned how the process worked in North Carolina and in Florida. I know Duke does business in both of those jurisdictions. I'm wondering if is the process used in those two states, is it readily available? So if our commission decided to look at that what was done in North Carolina or Florida, is that information readily available to us, or is that something that you could provide to us just as a late filed exhibit?
No,
Just
no,
curious.
Commissioner Irvin, we don't need to reference any
Okay. I
things that
apologize.
would for this
I'll
ex parte.
withdraw-
Thank
I
you.
understand. I'll withdraw that question. We'll deal with that issue as a commission at a later time. Thank you so much for answering my questions.
Thank you, sir.
Thank you, Commissioner Irvin. Commissioner Caston, I see your light.
Yes, ma'am. Thank you, Madam Chair. Thank you for your presentation. The term storm recovery property, I've seen it in the act, and I read what it said, and it was a totally different definition than I anticipated. I thought it would be property. But looking at the presentation, and I still want to make sure I understand it, is that, as it says in the terms, I guess the ability to collect or whatever, does that mean, especially on that last slide, that in that process of Duke, I guess, selling or transferring that to the, was that not SPF, that's sunscreen.
SPE, yes.
SPE, whatever it was. Is that what that means? It's literally selling, it's really transferring that right to do those things.
That's correct. So there's no physical asset, right? No asset that you can touch and feel that's moving from the utility to the SPE. It's an intangible piece of property. So it is that right to put the charge on customer bills, collect that cash from customers
Thank you.
for that term of the debt.
Thank you, Commissioner Thomas would have been here. I'd have probably asked him, but.
And I'll just add, Tom is exactly right. Told you I'm not a bond attorney, but I can at least say that, as I'm sure you're aware of, UCC, Uniform Commercial Code, Title 36, all about security interests, perfections of security interests. And so part of that requires property. And so the establishment and creation of said property then allows you to go through all the machinations needed to perfect security interests, things of that nature.
Thank you. I appreciate that. I get it. That cleared it up. Thank you.
Commissioner C. Williams.
Thank you, Chair Belzer, and thank you for the education. Appreciate your asking and your providing it. I'm just going to go through with my questions from your PowerPoint. So I'm looking at page 4 and the discussion about the 14.7 billion in multiple places. Is there any rule of thumb, big estimate for what the savings would be had with storm recovery in those circumstances? So you're saying, yeah, this is what was financed. What was the savings over the traditional method?
I don't know directly offhand in each of those jurisdictions, but I would say it would vary by jurisdiction. It would really be driven by what is that delta between the utility's cost of capital at that point in time versus the interest rates that they achieved on those financings. And so the interest rates, depending, and it also depends on the recovery period too. So the longer you finance, generally you would think higher savings. The shorter term you'd finance lower savings because you're collecting it over a shorter period of time. So it would vary. My guess would be significantly across those jurisdictions.
Okay. And on that same page, and thinking about the conversation about AAA bond rating, is what you're saying that it only works if you achieve the AAA bond rating? If you're, for some reason, you're not able to, the financing just doesn't produce a great enough savings?
It would get greater savings with a AAA rating. So but of all these securitization structures, we're talking about utility bond securitization, right? There's securitization's a broader term that's used for other things. So we're talking about just in the context of utility financings. All of these securitizations that have been done by utilities have all gotten AAA ratings with the exception of one. That was by Entergy New Orleans after Hurricane Katrina. So the financing they did, I don't know if it was for Katrina, but it was certainly after Hurricane Katrina hit. And the rating agencies saw, what happened in New Orleans after Hurricane Katrina, where massive amounts of people moved away. And so they were concerned about if that were to happen again, would the customer base evaporate and we would be left with a smaller body of customers. So every other securitization got AAA. So you could still get savings on a AA rated bond, but the idea is that it wouldn't be as significant as with a AAA rated bond, right? So the AAA is the highest credit quality in the market, but there's also an understanding that all AAAs are not the same. And so we would make the case to investors that these are the highest of the highest quality out there, which should get the lowest interest rate even compared to other AAA that are out there.
So what I take from that is there's no requirement that it be AAA, but that's the goal. That's
Right.
likely the best
Right.
return on the overall investment, using that term loosely.
Yeah. Yes, that's correct. Yep.
I was just gonna recall back to what I said initially about the different phases, legislative, regulatory, and all the different pieces, and ultimately trying to get to the lowest price possible. I kind of, in my mind, I look at it as this gauntlet that we go through with all ultimately essentially try to get that AAA rated. So all of these pieces, the machinations, the language, it's all about trying to get to that point.
That's the goal, but it's not a requirement that you get to that point, but it's the most likely, it's the best end product.
Exactly.
Okay. In terms of the, I've shifted to page 5, but at the end of the post-financing order, you talk about the periodic true-up of rates. Would you talk a little bit more about what that's likely to be like?
Sure. So the statute says that rates would be adjusted at least annually. In our North Carolina and our Florida transactions, both of those have adjustments of the rates on a semi-annual basis that are aligned with the actual bond payment date. So you're going through time, you're collecting cash, it goes to the trust makes a principal and interest payment, the trust has zero cash. And so the required payment for at the next date could be slightly different than what you had to collect at this point in time. And your sales forecast can be different depending on what your cutoff periods are. Right? So you would go in and adjust the rate, again, whether it's semi-annual, annual, but you would look at what is your debt service obligation over that 6-month or 12-month period. And that's when we price bonds, that's relatively set. So we're going to have scheduled amortization. That's not going to change over the time. It's going to be fixed rate debt. And so the interest requirement is also fixed. And so we know what those two pieces are. The only piece that really is subject to any variability is the estimate of ongoing expenses. So we have to pay the rating agencies to continue to monitor the transaction to ensure that it not only is AAA up front, but that it's AAA for the term of the financing as well. We have to pay the trustee for that, for its holding the cash, and it's got to make some money for providing that trust service. There's also some compensation that goes to the utility for being the servicer and the administrator of the transaction on behalf of the SPE, because remember that SPE has no employees. So the only part of the numerator that really is subject to change is the expenses, right? But they're not going to change significantly. They're small. It would be a small change. So, but what can change is your sales forecast for that 6-month period or annual period of time, right? And so you're going to set a rate that's saying what cash do I need to collect divided by my sales forecast for that period of time, turn that into a cents per kilowatt hour and put that on customer bills. But as you go through time, the one thing that's known in that whole thing is the forecast is not going to be the actual kilowatt hours that we deliver, right? It's going to be hotter in the summer or milder in the summer, colder in the winter, less cold in the winter. And so the actual sales volume is going to be different than the forecast. And that results in an under collection or over collection of what you need to make that debt service payment. If it's over collected, the cash stays in the trust, and we take that into consideration in the next true-up. So we give credit to that amount of cash already there. We need to collect total principal and interest payment minus what's already there, divide that by the sales forecast going forward. If we're under collected, there's a provision is usually in the financing order that says we can true up the rate in between the scheduled true up dates to be able to ensure there's enough cash there when we get to a payment date. So if we set a charge, we put it on customer bills, and we have an extremely mild summer, we're going to be under collected, and we'll need to go in and adjust the rate on an interim basis to get caught up by the next payment date to ensure there's cash in the trust to make that payment. Does that make sense, or?
Yes.
Okay.
But in addition, I guess I'm asking, what does that mean in terms of the relationship? And maybe you want to use the chart at the end in terms of the Public Service Commission as well as informing customers.
Okay. So yeah, there will be, in terms of noticing customers, there will be a new tariff that gets filed whenever that rate is trued up. There will be a period of time to be determined in the financing order as to what the review period of those true-up filings is. And so in North Carolina, it's 60 days. So if we want a rate to go effective on January 1, we have to file that true-up on December 1st. And there's a 30-day period of time for the public staff in North Carolina to audit that calculation, which really is a mathematical accuracy check, because again, that numerator, the total debt service obligation is known, and it's dividing, allocating that to customer classes. Are we doing that correctly? Or we're dividing it by the appropriate load forecast, sales forecast, or getting to the right cents per kilowatt hour charge. So it's really a mathematical and clerical accuracy check before that rate goes effective.
Thank you. My last question comes from, it was inspired by page 22, the last image.
Okay.
You've talked through a set of storms, but we don't have a set of storms and then we'd love to have a 5-year break or 20-year break, but of course they compound and they come again. Would you talk through what this is like from the perspective of, we have this first set that you're working on, but what happens in the big picture with the next set that you bundle together and bring through? And
Okay.
Does that make sense?
It does.
And in a big picture perspective, I don't need a deep dive.
So you would have this kind of all over again, right? So the transaction we're talking about here that we've gotten the prudency review ongoing for, is for those 8 sets of storms that Melissa mentioned. And so that's the only thing that can be included in this first transaction, right? We will, once we have an order on this, we'll file a financing order petition and move forward with recovering those costs and those costs only. So the next storm or sets of storms that hit, we would likely come in and request a deferral order for those costs, defer those till they come up to some dollar amount that we would think is beneficial for securitizing. And then we would come back and request prudency of the cost. We would request a new financing order, and we would do a separate transaction for that next body of costs. So that, though, depending on how we were to set up this SPE, this same entity might be able to be used for a second issuance, but it would have a separate financing order around that particular body of cost, and the charges for, set of storms A would be different than the charges for set of storm B. There's no blending of those together. Is that getting to what you're asking? Okay.
And from the customer's perspective, what would the bill line item be with one set of securitization, and with 2, what would it be like?
I don't think the statute would require 2 separate line items, although I think Kamal's going to look and correct me on that if I'm wrong, but there would be a separate line item on bills that says storm securitization charge or something like that. there's language around there that says that charge is being collected on behalf of the SPE and all those sorts of things. Whether there would have to be a second line item, I'm not sure or if we would just have one line item that would have both charges in it.
Oh, there we go. So I think it is a bit subject to interpretation as to what the statute would require or not. There is just one thing I did want to highlight. So what Tom is articulating is kind of the theoretical to directly answer your question. As you know, there's an ongoing docket that's also separate that has some overlap here. And so the real world as to, whether there be a set
Right.
of storms in the future, may or may not exist. So just wanted to flag that and
Okay.
make sure that was clear.
Thank you. No further questions, but I appreciate the education.
Thank you, Commissioner Williams. Commissioners, anything further for our panelists? Hearing none. Mr. Mustian, anything?
Madam Chair, would just remind everybody who is in attendance, either in person or virtually, to provide their certificates so that we can certify this, or at least have the ability to certify it. So just remind
Thank you.
everybody for that.
Thank you, Mr. Mustian. Mr. Ellaby, I did not mean to leave you out. Do you have anything further? Okay. Thank you. Panelists, thank you very much. This has been very informative, and we appreciate your work and your presentation and your attendance and your detailed explanations. Thank you. And with that, we will close this proceeding, and I wish everyone a good afternoon. Thank you.